get started. Hi, everyone. Thank you for joining us today for this webinar, HIV Data Privacy Criminalization, HIV Data Privacy, Criminalization, and the Role of Health Departments. My name is Dori Malazanov. I'm a Senior Manager on NASTAD's Health Systems Integration Team. Today, I'm going to talk about some research that NASTAD has been working on for a few years. It's an ever-evolving project, and I'm really excited to share it with you all where we are currently in this work. This research is focused on some of the legal protections that come into play when law enforcement entities, courts, or prosecutors request HIV surveillance data from a public health department with the intent of using it in connection with a criminal legal matter. We did a comprehensive legal review of privacy laws in 53 jurisdictions, and I'll talk through some key findings and themes from that research. We'll also hear from two exciting speakers that will offer different perspectives on how health departments can work with other stakeholders to ensure that HIV data is protected. I'll give them proper introductions before they each take the metaphorical stage, but please join me in welcoming Heather Anderson-Fintak from the Southern Nevada Health District and Adrian Guzman from the New York City Health Department. Thank you both so much for joining us today. After the presentations, we'll have time for Q&A. If you have a question for myself or for another presenter, please use the Q&A feature to submit it. It's got two little chat boxes on the symbol. If you use the chat for questions, we might miss them. But feel free to use the chat feature if you want to share information or thoughts with other attendees. This presentation is being recorded and will be made available to you all later along with the slide deck. So with that, let's get started. So generally speaking, HIV data held by health departments is confidential and cannot be shared without consent. But there are usually exceptions. These are state and territorial laws, so those exceptions vary by jurisdiction. For this project, we wanted to know whether any of those exceptions could result in disclosure of health department HIV data for use in a criminal legal matter. So here are a few common exceptions to state confidentiality laws that we found particularly relevant. The first two here seem like the most obviously applicable: adjudication of a criminal matter, in connection with a criminal investigation or prosecutions. Those are quite explicit. However, the third one here, to enforcing public health laws, that can also come into play because some HIV criminalization laws, as well as accompanying, some HIV criminalization laws and accompanying disclosure laws are found in the public health code rather than in the criminal code. And then some jurisdictions have very broad authority to share health department HIV data as long as there's a valid court order or subpoena. So ultimately, we found that while some states do explicitly prohibit release to law enforcement, courts, or prosecutors, most states allow it in at least some circumstances. So now let's dive into this newly updated NASTAD resource and the research that went into it. It's an interactive map summarizing state laws that govern whether and to what extent health departments can or must disclose HIV data to courts, prosecutors, and law enforcement agencies. It's current through November 2022. This update now includes 53 jurisdictions, 50 states, the District of Columbia, Puerto Rico, and the US Virgin Islands. This tool can help health departments get a digestible snapshot of the extent to which HIV data can be released for law enforcement purposes in their jurisdictions. When can they do it? When are they required to do it? And under what circumstances? We hope that it can be helpful for health departments and other stakeholders that are seeking to advocate for changes in state law, to better engage with community about this issue, and to develop agency policies that interpret and implement state law in the most protective way possible. The laws in this map apply to data that's maintained, created, held, or collected by state and local public health departments. But data that's potentially helpful in a prosecution can exist elsewhere, for example, in a healthcare provider's medical records. Since health department surveillance data is subject to state privacy laws, we looked at those laws for this research, but different or additional laws will come into play depending on which entity is in possession of the data that's being sought. We had a small team working on this, so we had to limit the scope to keep this project manageable. We created a research protocol that explains in detail all of our inclusion and exclusion criteria. It's available on the same webpage as this tool. We do have potential now to expand this work. Our legal research team has grown and keeps growing. So we do want to hear from all of you about how we can make this resource or future resources or technical assistance more helpful and meaningful for your work. Since the nexus between HIV surveillance data and criminalization is the impetus for this research, the first question we asked was, does the jurisdiction have a law criminalizing HIV transmission or exposure? We found that 35 of the 53 jurisdictions do have laws criminalizing or controlling behavior that could potentially lead to HIV exposure or transmission. Those 35 jurisdictions are the ones illuminated on this map here in blue. The other 18 jurisdictions aren't really a hard no for this question because each of them has at least one of the types of laws listed here. They're outside of our research criteria, but they can still cause people with HIV to be punished more severely for their actions simply based on their HIV status. So please read this no here with that caveat. If you're interested in more information about these laws, I'll drop some great links in the chat before we sign off that go into really great detail and analysis about HIV, the different ways in which laws are used to criminalize people with HIV. These 34 jurisdictions have laws that met our research criteria as permitting release of health department HIV data for law enforcement or criminal punishment purposes. So to meet our inclusion criteria, the law must explicitly permit or require health department HIV data release to law enforcement agencies, prosecutors, or courts in at least some circumstances that could result in the data being used in a criminal prosecution or investigation or other proceeding. The law might be specific about when and how data can be released for criminal matters, or it might be left up to judicial discretion. If a state is coded as no, that could mean the law explicitly, this is a non-exhaustive list here of options. If the state is coded as no, that could mean the law explicitly prohibits disclosure or admission into evidence. It could mean the law doesn't address it at all, or that it's so vague that we couldn't draw really meaningful conclusions from just reading what it says on paper. Again, we had to kind of limit the sources that we looked at for this iteration of this work. A no answer could also mean that the law has an exhaustive list of all the permissible disclosures, and this is not one of them. In other words, disclosure is only allowed in 3 specific kinds of situations, and none of those situations meet our research criteria. Those 19 no states are also coded as no for the remainder of the questions, the research questions. So for the remainder of the slides, the yes and no numbers are going to add up to 34 to reflect these 34 jurisdictions. They're not going to add up to 53. We also looked at whether a court order is required for the health department to disclose HIV data for law enforcement purposes. Our initial hypothesis was that requiring a court order is the most protective option, short of just prohibiting disclosure altogether. But I've since learned in my continued research that court orders like this can actually be pretty easy to get in some jurisdictions. And unfortunately, there are some judges that might even just rubber stamp them without thinking about them too much. So our guest speakers will talk more about this later, but I just wanted to highlight that this is an example of where education and collaboration with law enforcement, with legal counsel, even with judges, prosecutors, this can all come into play. Judges are usually supposed to do a risk-benefit analysis to weigh the need for disclosure against potential harms, and they often have a lot of discretion to decide if ordering disclosure is appropriate and fair. So it is important that they have the knowledge needed to make those decisions, that all entities kind of involved from beginning to end in requesting disclosure and reviewing requests and responding to them, kind of have the knowledge needed to make those decisions and consider all the relevant factors and potential ramifications. If a state is coded as no here, that could mean the law allows disclosure without a court order, for example, explicitly allows it. So for example, pursuant to a prosecutorial subpoena. But it's actually very common for the law simply not to specify what type of discovery instrument is needed, which again leaves room for health department and legal counsel interpretation. So that covers the circumstances in which release is allowed. How about the scope? Does the law limit the types of HIV data that the health department may release to courts, law enforcement, or prosecutors? Of the 34 jurisdictions allowing data release for law enforcement purposes, 17 limited disclosure to specific types of data, at least, in the language written in the laws and regulations. The most common specific type of data that might be permissible is HIV test results, which generally means diagnostic testing. I do think it's possible to argue that this could include molecular surveillance data as well, at least in some jurisdictions. But even without that link, this one is still very important. As of right now, molecular surveillance data has pretty limited usefulness when it comes to prosecutions, but health department records that someone tested positive for HIV and received counseling about their status about those test results are among the more useful data points a prosecutor could want. Knowledge of HIV status is an element of every HIV criminalization law in the country. Prosecutors have to prove that someone was HIV positive at the time of the alleged offense and that they actually knew their status. So HIV test results and counseling records records that the health department had counseled the person on their status are going to be helpful data points there, even without the molecular HIV surveillance component. If a state is coded as no, that means the law does not limit the types of data that can be disclosed. The most common language we found is a general authority to release, quote, all records and information in the health department's possession. Most likely what those records and information looked like at the time the law was written is very different than what that information looks like now. The health department and its legal counsel can potentially take this as an opportunity to interpret the law as narrowly as possible. Court orders also include limitations so that requests are limited to data that's relevant and necessary for fair adjudication. So there are other mechanisms outside the letter of the law that add protections, but permissive laws like this still create a risk of data misuse and over-disclosure. And finally, since this research is focused on misuse of data for law enforcement purposes, we wanted to know whether data can be released before someone is actually charged with a crime. So 0 jurisdictions explicitly required that someone be actually charged with a crime before data can be released. All 34 jurisdictions that allow release of health department data for these purposes either allow disclosure before charges have been filed, for example, to a grand jury or release for investigation. In most cases, though, the law does not specify whether the defendant must first be charged with a crime. So how does all of this relate to molecular HIV surveillance or MHS data? Even though we don't currently have evidence that MHS data is being disclosed for use in criminal matters, we still want to make sure that our data protections are as strong as possible because this kind of data could become more useful to prosecutors in the future. So here are some factors that currently limit disclosure and relevance of MHS data for criminal legal matters. So the laws that we looked at generally do not include direct reference to MHS or to cluster detection and response activities, or cluster detection and response or CDR. But we are still reading these laws with MHS and CDR in mind. Some laws are vague enough that they could arguably include MHS and CDR, even if these tools didn't even exist when the law was written. And as these and other public health interventions and data technologies continue to expand and evolve over time, there are other risks that could come up in the future that we can't even anticipate right now, making the need for proactive legal assessment very important as well. That's why we wanted to know here, what limitations and protections already exist. How can they be strengthened with or without statutory changes? Are there unintended harmful consequences from laws that were not written with this kind of disclosure in mind at all? And can any of this be remedied without statutory change? I think the ideal, right, is for every state to have a law that just prohibits disclosure for criminal law enforcement purposes, full stop. But changing statutes can be a long and arduous process. And there are strategic considerations depending on your jurisdiction about when and how you would move for that kind of change. So it's not the fastest or even the most predictable way of making changes in a lot of cases. It's also worth noting that even if MHS or cluster data can be released for law enforcement purposes, the data itself is not especially relevant for proving the elements of a crime. On the other hand, that could change over time, which is, again, why a proactive legal assessment is important. And that's why we're hoping that our research, that's what we're hoping that our research can support. There are practical barriers to using the data for prosecutions as well. A prosecutor would need to request comparator data for a very large number of people, maybe even for an entire state, to actually connect people in a cluster. Data for just the two people involved in the case, the alleged defendant and alleged victim, is not enough. I don't want to dismiss the fear that an overzealous prosecutor could try to make a case anyway. We all know prosecutions can happen based on scant evidence and manipulated science. So I'm not saying that it could never happen, and we should certainly shore up our data protections to make it impossible. But I do want to note that there are very real relevance and logistics issues that prosecutors would need to overcome. So before turning it over to our first speaker, I'm going to drop something in the chat after I'm finished speaking for folks to read when you have a chance. It's really interesting. It's a charging guidance from the New Jersey Attorney General's office. Essentially, it says that prosecutors should be very selective about charging people under the state criminalization law. So it's an example of how an agency policy that deprioritizes HIV status-based crimes can definitely, can reduce the need for health department HIV data, thus reduce the need for these types of requests, especially when changing the criminal laws or the data laws is not feasible. So without further ado, I would like to introduce our first speaker, Heather Anderson-Fintak. Heather is General Counsel for the Southern Nevada Health District, which serves the Las Vegas area. The Southern Nevada Health District is one of the 10 largest local health departments in the United States, serving 2.2 million residents and 43 million annual visitors to Las Vegas, which I have to say, Heather, is a fact that has stuck in my brain ever since you told me about it. With that, I will turn it over to Heather.
All right, well, thanks so much. Hopefully my sound is good. As Dory just introduced me, I do want to tell you a little bit about the Southern Nevada Health District, and then I'm going to launch into the reason why I've been asked to speak today. So as was said, we are one of the largest health districts, local health districts in the United States. We have over 800 employees, and we're our own local government. So this is very advantageous for us that we have two in-house legal counsel. I'm general counsel, and I've been with the health district for over 10 years now. I started as associate general counsel. This allows me to build relationships with staff and really be a part of the mission. And I know that that is not always something that health department staff get to have. A lot of the health departments rely upon civil DA's office in order to provide them the representation that they need. But an important relationship with your legal counsel can make the difference on how you can proceed. So in Nevada, we obviously do surveillance we have 73% of the population for the state of Nevada that lives in Clark County, and we're not the county seat or the capital of the state. So that is somewhere completely different. But we have a lot of control over our funds and how we proceed. We have our surveillance staff do HIV and communicable disease surveillance, and we do work with them on a variety of issues. Now, HIPAA is permissive for the purposes of disclosure of HIV records to law enforcement. However, I do like Nevada's laws, and I do use it in a way that is advantageous to our staff. And NRS 4418-220 only allows us to disclose if there were a court order. That way I can protect that surveillance, that communicable disease and surveillance data. What was happening in Nevada until the change of the law from intentional transmission of HIV was a felony up until the last legislative session, were every other year. So that was in 21, is that intentional transmission of HIV was a felony. So what the prosecutors in Nevada would use this for is an upcharge. So sex workers and others would end up with a felony charge on what would otherwise have been misdemeanors, whether that was solicitation or molestation or inappropriate conduct with a minor. They would then add this felony charge. This is different than the protection statutes that allow the health department to test victims of sexual crimes and then provide those test results directly to those victims, as well as the test results of the accused, so that the victims would know. And we've had to give those awful test results of syphilis and gonorrhea to parents of 9, 10-year-old children. That's not what we're talking about here. What we're talking about is the HIV data and the intentional transmission. And if you could see me, I would be doing air quotes with my fingers, because the lawyers know that intentional crimes usually requires an intent. But for the intentional transmission of HIV, you don't have to be intending to transmit it as if it were like you were weaponizing it, which is, the idea behind these crimes initially, but more about the intent of having sex. So this is the only sexually transmitted disease that has been criminalized, and in Nevada, it used to be a felony. So what did I do? What had the health department before I even got there did is when police officers submitted requests, we would say no. When we would receive an administrative subpoena, we would say no. When DAs issued subpoenas to us, we would file, serve them with an objection letter. And then, as Dory said, it is very easy for DAs to go to court and get an ex parte court order to obtain these medical records. And ex parte means that they don't tell the other side. For the non-lawyers in the room, they don't tell the other side, which means that we didn't get a chance to object to that process. So when we get an ex parte court order, we file a motion to quash. So what we've done is we've just not given that HIV data, those HIV records, up for the purposes of law enforcement criminalization. And really, this has been a successful way for us to stop them. And the statute used to say that it required and this is where we get the health department involved, it required the test result of the state board of health. Well, again, Las Vegas, Clark County, we are, 73% of the population. What are the odds that it was tested in Northern Nevada? More likely than not, it was gone through us. And so it's just easier to try to get the records from us. But when law enforcement realized it wasn't easier, that stopped. And we just stopped receiving requests. So we were able, in our small way, to stop that. Now, I'd like to share one case that I fought particularly hard not to give up the data on. And unfortunately, with, again, criminalization, criminal cases, something like 90 to 95% of criminal cases settle. So once you get charged, regardless of whether or not you're innocent, regardless of who you have as, defending you, this isn't, Perry Mason happening. Most of the time people plead out to cases because facing the full consequences is something that they're unable to do. So I followed the case after I refused to provide those records. And with this particular case, this gentleman had offered to pay someone for services from Craigslist. And the person who showed up and provided him with a hand job was the age of 15. And when he was arrested for the inappropriate conduct with the minor, he then informed the jail that he had HIV. Then he received that additional charge to felony for the intentional transmission of HIV. And reading the minutes when he was pleading guilty, he said to the judge, "Don't you know how HIV is transmitted?" And the judge's response was, "Are you withdrawing your guilty plea?" And he said no. Well, he served 4 years. So he served that time, and he was in jail until November of 2021. So unfortunately, the change of the law did not help him at all. But that was, and this is just one example that I know of because I was involved, where they were able to get a plea out of this individual. But I want my message, of course, in to our staff and working with our staff is that public health is our goal. Public health is the most important aspect of this. So I am not interested in helping the police criminally charge people. My goal is to make sure that the health department is a place that you can get treatment, that we are the place that you can trust us not to share your information. Otherwise, we cannot be successful in protecting the public health if we don't have the public's trust. So that is why I have taken the position and I have, and I am willing to pay outside attorneys to help me if it becomes an issue. But what I can tell you is from the time period of the change of the law, I have not heard of any additional charges. It's been reduced to a misdemeanor. It's just not worth the effort for those DAs to prosecute the case. So if all of you listening have an ability to influence, just merely taking down the criminalization from a felony to a misdemeanor makes it just untenable for the purposes of pursuing these. So thank you very much. That's it for my presentation.
Great. Thank you so much, Heather. Heather, I see some questions are coming in. That's great. Keep them coming. We'll have time for questions after the next presentation. So with that, I would like to introduce our next speaker. Adrian Guzman joins us from the New York City Health Department, where he serves as Director of Policy and External Affairs for the New York City Department of Health and Mental Hygiene's Bureau of Hepatitis, HIV, and Sexually Transmitted Infections. I think Adrian has some slides to share. Perfect. They're up. And Adrian, please take it away.
Thank you. Thank you very much. And thanks everyone for joining us this afternoon. I'm grateful to share a little bit about our work on data privacy criminalization here in New York City at the New York City Department of Health and Mental Hygiene. So first, I want to talk a little bit about HIV criminalization and data privacy reform efforts, specifically on how we've seen our role as a health department here in New York City. And then I'll share two brief case studies. One, how we've engaged with criminal justice stakeholders, including prosecutors, in our New York City task force on the health and safety of sex workers. And then a second case study on some, usually I have to say upcoming, but now I can say current work because we're moving along nicely. Some current work we're doing on HIV and criminal justice here in New York City, working with the NYPD and district attorneys and other stakeholders. So as we consider it, HIV criminalization and data privacy, it's important to have a really central role as a health department. I think that our role can be broken down into three different pillars. One, it's our responsibility to really center evidence-based public health practice when we're having HIV criminalization conversations. It's also our obligation to communicate that sexual health is the responsibility of both partners and make sure that we equip them with the information and tools necessary to protect themselves and others. And then third, we have an obligation to partner with criminal justice stakeholders. And I want to talk a little bit more about this third pillar. So when we talk about partnering, these are our sort of best practices that we've developed. First, you want to identify the criminal justice stakeholders that are essential to HIV criminalization conversations. So obviously that includes frontline law enforcement officers, including from vice squads or even the community policing units. A lot of law enforcement agencies have LGBTQ and other community liaisons. Here in New York City, we have a mayor's office for criminal justice. And then, of course, prosecutors, public defenders, bar associations, court systems. And let me just add one other item, which I'm embarrassed to think that I hadn't thought of this before one of our community partners mentioned it. But people affected by the criminal justice system are criminal justice stakeholders. And it's important to have them involved in these conversations when we're talking to officials. So I think that's an important addition. Second, it's important to be strategic when convening these stakeholders. All of those I just listed are coming from very diverse backgrounds with very diverse interests and goals. And so it's important to think about when and to what extent they should come together and what the timeline should be when engaging them on this work. And then it's important throughout the process to emphasize common goals. There are a couple that we've really focused on. Protecting and promoting public health and safety. We're all on the same page when we want to build community trust and cooperation. And of course, I think anyone involved in city government is hopefully committed to improving interagency communications and collaborations. One approach we've taken is to always frame these partnerships as an opportunity to leverage each other's experiences and expertise. We never, as much as we'd like to sometimes, we never characterize a partnership as a sort of unilateral corrective intervention by the health department. We're not coming in and telling them what they need to do or how they need to do it or what they're doing wrong. We want to highlight what they can bring to the table as well. It's important to remind of past partnerships. For us, we've had a couple of engagement opportunities with the NYPD on related public health issues that have gone well, and we want to rely on those as we encourage them to partner with us in the future. And depending on where you're coming from, this may be a benefit and it may work against you, but it's always important to remember that there is federal support for HIV criminalization reform from the CDC, from HRSA, from HHS more broadly, but in recent years, they've come out with stronger and stronger supportive statements on the need to, at the very least, examine these laws and policies and determine what can be done so that we don't target people with HIV in stigmatizing ways. And then the last two, definitely take on the role as a convener of the partnership to ensure momentum. Obviously, this is a partnership and everybody should have a say in the planning. But if you are the one in charge of scheduling meetings, setting the agendas, at least initially, this will keep momentum. And lastly, establish an intended agenda and goals prior to convening the stakeholders. Have a plan of action going into these conversations so you can steer things in the appropriate direction. So I wanted to close with two case studies. The first, as I mentioned, was on our task force on the health and safety of sex workers. So several years ago, following FOSTA, SESTA, a couple of policy leads from various New York City government agencies came together to think about what we're doing around sex work and how we are engaging sex workers. We did an inventory of our current services, and as you can imagine, only two city agencies were doing anything. The health department, which was actively working with sex workers and organizations to address their health needs, and the NYPD, which was arresting them. So it definitely was a learning curve for all of us, and we thought it best to engage our First Lady at the time, First Lady Charlene McCray. She was really supportive. She hosted a small group of sex workers and their advocates at the mayor's Gracie Mansion to share their experiences and identify urgent needs. And we continue to work together to discuss enhancing our existing policies and programming or to establish new ones. And then just before COVID, as part of the New York City Police Reform and Reinvention Plan, the mayor launched an actual formal task force. And in the course of this work, we began engaging prosecutors and other criminal justice stakeholders as part of the second pillar, which is on the right, the shifting police policy and practice. And this was done in collaboration with our City University of New York and various city agencies like us, the health department, as well as the mayor's office for Criminal Justice and our Mayor's Office to End Gender-Based Violence. And this is just a sort of infographic that talks about what we've been doing the last couple of years. We've held structured interviews, not only with people involved in the sex trades and their providers, but also police and prosecutors. We've been reviewing policies and we've been engaging all the different agencies involved. And I just want to mention that simultaneous to this, there's been a lot of sort of behind the scenes advocacy specific to the district attorneys. And one by one, four of our 5 district attorneys have announced very publicly pulling back on some of the targeting of sex workers. Since 2021, Bronx, Brooklyn, Manhattan, and Queens district attorneys announced that their offices would dismiss hundreds of cases involving prostitution or the loitering for the purpose of prostitution offense. And then in February of 2021, our governor signed into law legislation repealing that loitering for the purpose of engaging in a prostitution offense. So that's just a sort of snapshot of what we've done in a similar area when it comes to public health and criminal justice engagement. But I want to close with talking about our efforts specific to HIV criminalization. Back in summer of 2021, we began exploring how we can address the intersection of HIV and criminal justice, specifically in New York City. We were really inspired by a New York City prosecutors roundtable that various organizations held, including the Association of Prosecuting Attorneys and the Center for HIV Law and Policy. It brought together all sorts of advocates, and we wanted to make sure that we could keep the momentum. And so we did so by relying on federal funding, which was really exciting. In the spring of last year, the CDC approved our request to use CDC 18-1802 spend down funding to support our HIV and criminal justice project proposals. So we began working on identifying partner agencies that could actually carry out this work. We were outsourcing everything to our community partners. Around the same time, I was very lucky, grateful to join the White House convening on HIV criminalization, which was an excellent opportunity to see in real time what these conversations with prosecutors, health department officials, and federal government officials, what they'd look like and what we'd like to model our own local conversations on. And then in January of this year, we awarded funding to the Center for HIV Law and Policy to carry out our 2 projects. The first is our HIV Criminal Justice Stakeholders Project. The Center for HIV Law and Policy is currently developing informational products like palm cards and fact sheets. And actually, as of yesterday, when I met with them, we're looking at maybe doing some videos and animation for a diverse array of criminal justice stakeholders. So all of these materials will be tailored to different groups, NYPD, frontline officers, prosecutors, public defenders. All of them will focus on the basics of HIV and other infectious disease transmission, and also remind them about existing requirements under state law when it comes to discrimination and confidentiality. And we also hope to reimagine these materials into in-person training opportunities so that we can deliver this information in a more impactful way to all of these stakeholders. And then the second and final project they're working on next will be for the Center for HIV Law and Policy to conduct analyses of our own local and state legislation, regulations, and policies. And this will be more about what Heather just spoke about, what do our laws and frankly, our internal informal protocols look like when it comes to subpoenas for HIV-related information? What are our confidentiality protections as a health department? And they're going to go through all of that and then develop recommendations for improving outdated or stigmatizing content. And then they will help us. They'll provide technical assistance to help us update all of these policies as needed for the protection of staff and for the protection of New Yorkers with HIV. And then this last bullet is really important to me. Here in New York State, we don't have an HIV-specific criminal statute, which is not to say that we haven't had a small number of people with HIV targeted on the basis of their status under traditional criminal laws. But we're lucky in a sense that we don't have any specific criminal statutes on HIV that we have to repeal or modernize. But I think as the largest health department in the country and as a leader in a lot of this work, we have a responsibility to promote our work to other jurisdictions and help them understand how they can use CDC funding to carry out this work, share with them our best practices and our worst practices. So it's really important to me to make sure we communicate everything that we're doing. And yeah, so we're working on this as we speak. Like I said, I had a meeting yesterday. We're really excited with the Center for HIV Law and Policy. They've also brought on as a consultant transgender equity consulting led by Cecilia Gentili, who is doing a lot of the community engagement work. And meanwhile, I've been working on engaging my city government colleagues to kind of put this on their radar and know that we'll be coming to them soon to share these materials and trainings. And that's what I have. Thank you again for the time and opportunity to share all this.
Thank you so much, Adrian. That was a great presentation. We have some good questions that have come in. So I'm gonna jump right into those here. Okay, I think this first question is for Heather. Heather, can you speak to how your health department arrived at this general practice of declining to cooperate with police requests? What staff roles and community voices might have been involved in this decision? And what advice do you have for other health departments looking to adopt similar practices? So it's a multiple layer question.
It is, and it's not an easy one. I would say that it started with the fact that both myself and my prior boss, the general counsel, came from a place of protecting individuals' rights. And even though the health department in some ways has a role that it needs to, for example, in regulations and environmental health, to ensure that the food that enters your that enters on your plate from a restaurant is safe, and we can shut restaurants down. We want to make sure that we're protecting people's rights and people's access. So it started that really it was very simply a conversation between our staff who did the disease surveillance and us in the legal department, and how could we go about and make sure that we are working together. And I know that some of the conversations that came up when NASTAD was doing this research is our staff kept on getting asked, well, how do you do this? How do you do that? And go, well, we'll just give it to Heather. And that's a clear message that when legal needs to get involved, when police are asking for too much, and the reality is we have 3 people who are at Clark County Detention Center who provide testing to inmates who are there, and not for the purposes of criminalization, but just to ensure that there's no communicable diseases that are passed while in jail. And so we do have to have a relationship, but there is a boundary, and what our goals are is public health, and it differs, and remembering where that boundary is. So it was really just a working of staff and legal together to make sure that we were meeting what we believed was individuals' rights of privacy.
Great, thank you, Heather. I know that that question was more for Heather, but Adrian, if you have just want to see if you have anything that you wanted to add or share about that question, because it's a big and important one. If not, I will move on.
Well, just that I look forward to being able to answer that question as we complete our work, when we work with Center for HIV Law and Policy, to hear from them about what they suggest that we do once they do a more comprehensive analysis of what our legal framework is around these issues, and then see where we go from there. I know that they have planned some community forums where we'll talk specifically about concerns the community might have and how we can address them. So I guess my answer is to engage experts in this area and have them tell you what they think.
Great, thank you. This next question, I think, is for both Adrian and Heather, since you are both here representing local health departments. How have you, or do you work with or coordinate with your state health department to, do HIV criminalization work, which I'm assuming kind of means advocating against HIV criminalization, reforming those laws? What is from your local health department perspective, what does that collaboration or coordination with state health departments look like?
Well, I could just mention that we're very, very grateful to have an excellent relationship with our New York State Department of Health colleagues. They've been incredibly supportive ever since 2014, when they first launched our statewide blueprint to end the epidemic, which included some content around HIV criminalization and stigmatization. So we haven't done any work with them specifically on HIV criminalization. We know that conceptually we're on the same page, and we'll engage them further as we continue our work on the two projects I described. But here in New York, all HIV matters are matters of state purview, so they are a critical partner in these conversations, and we look forward to relying on our long-standing relationship to hopefully get us across the finish line on some of these projects.
Great, thank you. Heather, do you have anything to share about that question?
Not really. Thank you.
Fair enough. How can I think this is also a question for potentially both, maybe a little more for Adrian. How do health departments repair lost trust if they previously have shared information?
I would like to take a
Yeah,
stab
I
at
think
that
it
if
might
you
be
would.
better for Heather.
Please.
Yeah.
Please
Thank
do.
So, and the at issue is what we've seen is we can't repair something that happened 15 years ago, but people don't forget. And we've seen, we had a provider in our community who I received a copy of a letter where he was condemning us for sharing his HIV status. I mean, we're talking about the early 2000s, where that he accused us of sharing his status. And unfortunately, it was so long ago, I can't even figure out how that may have occurred, but it was one of his hurts and hangups that he had. And he's a great partner for us to have in the community. So for him to still hold on to that, even as he's such a great community advocate for us, as well as a recipient of some of our federal pass-through dollars, the problem is I think it's really hard, and it takes a really long time, and you have to ensure that you're doing the work with the community and the community partners to know that what may have happened in the past would not happen now, and having a good relationship so that they know our process and our procedures, so that they have trust in us. But again, you can't fix. I mean, as I said, this person's holding something from 2007 or something like that. It's not good. So,
Adrian, do you have anything to add about that question?
To my knowledge, we've never been in a situation where we've been asked to share HIV-related information as part of a criminal proceeding. Certainly not since I've been at the health department for almost 8 years. And our HIV epidemiology lead, who oversees some of our molecular HIV surveillance, has been here since before the first reports of what we would come to know as HIV were published in the early 80s. And she too doesn't recall any instance, but I think it's a difficult situation. I agree with what Heather said. It's case by case basis on how to repair something like that.
Thank you. Can a court order ever override a law that when the law says that HIV data cannot be shared? Can a court order override that? And if so, under what circumstances? And then also, does it matter if the court order is from a different state? in your, opinions, even if this is maybe not like legally what is playing out in your jurisdictions?
Well, I am licensed to practice law in Nevada. I also happen to be licensed to practice law in Maryland, but I'm inactive. So I can only tell you what Nevada says about outside court orders. And guess what I can do? I have the ability to ignore a court order from another state. They have to domesticate that order, meaning they have to go through the Nevada courts to have a Nevada judge recognize that court order in order to enforce it. Otherwise, I can blatantly ignore it. So, I mean, I know that this is much more, in the news topic as of late, but the, prosecution of, reproductive health aspects, and I'm, again, regular doctors' offices are not going to have legal staff available to them. And that's why there's some protections that you've seen argued in various states. But that's a great aspect of, I don't have to be responsive to something out of state. Now, on a federal level, yes, I do. If I get something from a federal district court, I have to be responsive. I get something from California, I write them a letter and say, no, thank you.
Thank you. We appreciate your willingness to say no in as many situations as possible. Thank you for sharing. Does anyone, Adrian or Amy, this admittedly is a little out of my procedural knowledge, but if Amy, Adrian, if you have any more thoughts about this question, it sounds like at least the part about the court order being from a different state, it might be depending on your jurisdiction, the ability to kind of ignore that may vary, but it sounds like at least in some jurisdictions, you don't necessarily have to pay attention to a court order from another state, at least in this context. So if anyone has anything else to share about, whether a court order could possibly ever override a law that prohibits disclosure, I would love to hear that from you all. Otherwise, I might have to kind of do a little more research and think about that a little bit more.
Yeah, I can't speak to the out-of-state thing. My guess is that it's similar to what Heather described from her jurisdiction. But in New York State, we do our public health law does allow for a judge to issue a special court order that would require the release of HIV-related information. So just because it hasn't happened doesn't mean it can't happen, which is part of my goal with this HIV and criminalization project, so we can identify that and then address it.
Great, thank you. As HIV. Okay, as HIV criminalization is often raised during community conversations about cluster detection and response and molecular surveillance, do your health departments work with your disease intervention staff, contact tracers, et cetera, related to HIV data privacy? How can these staff help communicate about HIV data privacy to their clients?
I can just briefly mention that a couple of years ago, the CDC funded New York State, New York City, Texas, and Houston for a demonstration project related to cluster detection and response specific to Latino MSM. So we were one of those 4 jurisdictions, and a component of that project was engaging our we call them ACE team, Assess, Connect, Engage, our DIS specific to HIV cases on these special issues. So we definitely train them for that, and continue to train them as we do all of our cluster detection and response efforts.
Great, thank you. Anyone else have anything to share about that question before I move on? All right. Are there any states that are good models for reforming HIV criminalization and release of health department data laws?
hoping you guys have the answer to
Yeah,
that
I was going to
question.
say that's my question too. I mean, I have some guesses, but only because I've heard you say them before.
I mean, good models, I think a good model for an HIV criminalization law is a little bit of a contradiction.
Yeah.
I think that Heather talked about, for example, like bringing down I think eliminating felony charges is like just a baseline reform that I like is like, if nothing else, that is a necessary one. But it kind of depends. I think we've heard from different jurisdictions that, what is that, for example, on the one hand, like full repeal might be something that sounds like the best option, or that might be what a jurisdiction is going for. But then perhaps in that jurisdiction, in another jurisdiction, reforming the law but not eliminating it can actually have some like other strategic advantages. So I think that good model for criminalization is a little bit hard to say, because even the absence of an HIV specific criminal law doesn't eliminate the problem of HIV criminalization. Like those laws are not the only source of that. In terms of release of health department HIV data laws, I think for me, it's a jurisdiction like I believe Arizona off the top of my head, just says a court may not order state or local any health department to release this data, period. A court just cannot order it. That would be an example of, I think, just a complete, just like full stop on any of this kind of disclosure being allowed for a health department from the health department for these types, for legal matters, criminal matters. I think would be a good model. There's not many though.
Well, and I can tell you what happened in Nevada is the state was very involved in this, and we had partnered with one of our senators with an HIV policy group, but what they wanted to do was a full modernization. So I would have been 100% on board with both hands up in the air for the decriminalization of just striking the statute of the intentional transmission of HIV. But then, because people wanted to make changes who didn't know our laws and didn't understand how they all mixed together, there was a wholesale change to isolation and quarantine laws, which isolation and quarantine, we only use that for active contagious communicable diseases as defined under the statute, and that's not HIV. But that changed surveillance and our surveillance staff, like how they access the property, and so we were not engaged in that process. The state was, but that was some frustrations as we wanted to be supportive of the bill, but then they started making a whole lot of other changes. But it depends on your state, depends on the makeup of the legislature at that moment, and what can you get passed. Do you need a full-scale change of all of our communicable disease laws? And I think those of us who work for the health department may have a different perspective regarding those changes. So that's my 2 cents.
Oh, sorry, I was muted. Thank you so much. It's now 3:01, so I do want to mind everyone's time. I've thrown my email address back up here on the screen. So feel free to save it and reach out with any additional questions. I know Adrian had also provided his email address, so I'll move to that slide here too. And I will follow up with everyone with a recording and slides, and I'll also reshare contact information. So if additional questions come up, please don't hesitate to reach out to me. I've dropped my email address in the chat. And thank you for joining us, and we hope you have a great rest of your Friday.
Thank you very much for having me. Thank you.
Yes, thank you so much again to Heather and Adrian for joining us. It's been great to hear from you. We appreciate all of your amazing work, and we love having you join us. So thank you.